Hello to everyone in the room and online. We have a system now just so that folks know where the online people can see us, which is great. It's much more interactive. I'm Jessica Sarnowski. I'm the Director of Professional Education for ELI. Wanted to thank our co-sponsors, the DC Bar Environment, Energy, and Natural Resources section. This is ELI Summer School, which is a great program. I wanted to just start with a quick show of hands in the room to see how many of you are currently students. Quite a few, okay. How many of you are working professionals? In what? That's a good question. In what? How many of you are non-lawyers? Okay, excellent. This is good. It's a good crowd. I'm going to jump right in and let our panelists introduce themselves briefly. We've got Jane Davenport from Defenders of Wildlife, and we've got Jamie Auslander from Beveridge and Diamond. So you've got two different perspectives, private sector and public, and I know that Jane was in the government previously, so you've got a lot of resources available to you. And this is NEPA and ESA.
Oh no.
Oh no.
Right.
Why don't you go first?
Hi, I'm Jane Davenport. I'm a staff attorney at Defenders of Wildlife, where I do a lot of litigation and policy and advocacy work centering on the Endangered Species Act, as well as Clean Water Act, NEPA, other statutes. I started out my career at the Department of Justice in Environment and Natural Resources, Wildlife and Marine Resources section, and then from there moved to the nonprofit world at the Ocean Conservancy, Oceana, and Delaware Riverkeeper Network. So the ESA is certainly something I've been working on for a long time, and it's a statute that's very near and dear to my heart. It's a short little statute. I highly commend it to you for reading. It doesn't take very long, but there's a lot going on with it. So I will look forward to giving you more of an introduction to it after Jamie Auslander finishes his NEPA presentation.
Sure. And my name's Jamie Auslander. I also started a very brief stint in the NRD, but I was in what's now the law and policy section. So very shortly after, I came over to Beveridge and Diamond, where I've been for about a decade now, and my practice focuses on project development. So I'm doing mostly NEPA, doing quite a bit of ESA and other federal minerals and natural resources laws for a variety of sectors, energy, transportation, sort of what have you. And it's a really exciting time, and in both of these statutes, a lot of they're both really old, but a lot of new issues and new law that are kind of just coming around now. So look forward to a discussion today, and your questions, and talking with you afterwards. So.
Actually, speaking of questions, I forgot to mention, for those in the room, we'll pass around a mic, and the folks online can hear their questions, so you don't have to repeat them. For the people online, please type your questions into GoTo webinar, and they will be forwarded to me, and we'll integrate them into the discussion. Okay.
Excellent. Well, I guess I'll kick it off. What do I?
There you go.
So this will advance it.
You just write.
Okay, perfect. Well, thank you everybody for coming. I'm really impressed with the attendance because, let's be honest, two words that probably don't go together: summer and school. And so I'm always just, the people we have here, the people having a phone, really grateful that you're here. When I was younger, people used to go to camp for basketball or baseball, and I didn't have much of a jump shot, and I couldn't hit a fastball, so I like to go to the local college and kind of take a course on something, and I was sort of, one word in reaction was dork. So thank you all for being dorks with me today, but it should be well worth your time. Also, just sort of start with a qualifier. I teach on this quite a bit. I did last year a full day on just NEPA. Been tasked to do it in 30 to 40 minutes, so I'm not going to rush through everything. I'm going to try to hit highlights and tell you what you really need to know to be well versed in the statute. But just come with your questions, and happy to talk with any of you afterwards. It's just I'm not going to try to cram an impossible amount into your time, and I know you're all busy, so we don't want to keep you here longer than you need to be. We will finish on time, I promise you. So let's just start. My task is NEPA, so let's just start and kind of take a step back in time. So 1960s. It's a pretty boring time. Nothing much going on. The average price a gallon of gasoline, 35 cents. No one knew what a mobile phone was. It meant taking your rotary and throwing it out the window. In this era, the effects of industrialization were really coming to bear, and kind of an environmental consciousness took hold of the public, and it made its way to the elected representatives in Washington. And of all administrations, the Nixon administration was the one who was there really at the beginning. A lot of debate previously in previous decades about what to do. There were some individual one-off statutes like the Wilderness Act or an ancestor of the Clean Air Act, but there really weren't any comprehensive environmental laws that were out there. But like most things, what the main trigger was a calamity, and that always triggers action. In this instance, it was on January 28, 1969. There was a blowout 3 miles offshore of Santa Barbara, impacting miles of California. You guys have seen all the pictures. It was pre-Deepwater Horizon, pre-Exxon Valdez, but it was a big event. It caught pretty much the nation's attention. And we just saw, a redux of that, of course, just left Santa Barbara. So these ruins are really very slow to heal, people remember. But stuff that's going on, and I just put this in because I think Adam West really makes any presentation better. So it was decided that the best approach was to declare a national environmental policy. And that really led to the first big statute, which is the National Environmental Policy Act, not Protection Act, but Policy Act. And I'll get back to that in a minute, 1969. And the point was that we needed some framework for federal agencies to consider pollution and the effects of their actions on the environment, to have a master framework for doing that. So NEPA overwhelmingly passed. Congress did it almost unanimously. You wouldn't see that today, but that happened. NEPA became known as the Magna Carta of environmental law. But environmental laws are more than you can't just have one, kind of like potato chips. So we had NEPA, then we had EPA created concurrently, had our first Earth Day. The Clean Air Act, as we know it, came out in 1970. Clean Water Act, 1972. We're still fighting issues under that. The new rule on proposed and now finalized on waters of the United States, but that's all under the 1972 law. Endangered Species Act, we'll be talking about today, the next year. Resource Recovery and the Resource Conservation and Recovery Act. 1976, and CERCLA and Superfund in 1980. So a whole bunch of rapid succession statutes. And we'll be covering these in later sessions of ELI, but I want to give you a sense of where NEPA kind of stood in the grand panoply of environmental laws. For the non-lawyers in the room and for those who are still in law school, I just wanted to cover so we're all on the same page about when I'm talking about law, what it is I'm talking about. There is a hierarchy. The one thing you don't see on this slide, or you actually do see at the very top, is the Constitution, right? The supreme law of the land. Environmental law is kind of unique in that you really run into constitutional issues all the time. So what am I talking about? Commerce clause. So there's an issue, a case in Utah where does the Endangered Species Act allow Congress to regulate species that are within a single state? All right, so that's, these are questions that are not fully settled across the country. So that's an issue. Takings under the Fifth Amendment, uncompensated takings. Other issues of preemption. These are all big issues under the Constitution that really rear their heads in a lot of different areas of environmental law. Underneath the Constitution, you have statutes, and what Congress passes, all the various acts that I listed on the previous slide. They control, of course, the statutes don't say everything, don't leave the details for the federal agencies to implement, and so they implement those via regulations. The regulations are supposed to fill the gaps, but sometimes they don't fill the gaps, and so we need judicial review and interpretation to tell us what the statutes or the regulations say or what they mean, or what Congress and the agencies meant. and that happens through case law, and there's a whole hierarchy of that, starting with the Supreme Court, the federal courts of appeals, the federal district courts, and then there's, of course, state law and state courts all across the country. So, what controls might differ in different parts of the country where you don't have a unanimous rule coming from the Supreme Court. And then we have gaps that are filled not through rulemaking, but we'll call guidance or informal policy, presidential executive orders. These do not have the effect of law as a legal matter, but they do as a practical matter. So if the agency tells you if you want to go build a wind turbine, you have to follow the following land and water protection guidelines, and you decide not to, well, you're probably going to find yourself more readily in an enforcement posture than if you didn't. Is it a rule? No, but you better listen to what guidance. And one of the big issues now, and not just environmental law, but general law, is how much can agencies do via guidance as opposed to rulemaking, which has formal notice and comment procedures and requires formal protection so that regulated entities know what's coming and they have an opportunity to comment before rules are finalized. So again, with that background, sort of launch into NEPA. So NEPA, you see a code site here, and I'm not going to do a whole lot of citation here, but again, I can give you sites to any of these things if you want to afterwards, but it's codified with statute. It's implemented primarily by the Council on Environmental Quality, which is housed in the White House, and that agency is tasked with creating NEPA policy across the government. So there are a set of regulations under CEQ that tell you what the various, how you approach various topics under NEPA, what various words in the statute mean, and kind of give some guidance that we're going to go over today. But they aren't ubiquitous, and so each agency has to implement NEPA, and each agency does something different, right? So the Department of Transportation does something different, Department of Interior does something different, EPA does something different. So each agency then has its own rules that sort of fill in with additional detail. Some of them just incorporate by reference the CEQ regs. Some of them have more specificity. For instance, the Department of Transportation can tell what kind of projects, need a full-blown environmental impact statement, like when you're building a new interchange, as opposed to like when you're striping the road, which is kind of an inconsequential action. You could do that with a categorical exclusion. We'll get into what those all are very soon. But NEPA, recently, now 40 plus years old. Again, as I noted, it's the National Environmental Policy Act. Often you see National Environmental Protection Act, even in court opinions. It's a really important difference because it was, again, intended to form a framework for agencies to consider the environment when they're undertaking their actions before they act. It's a look before you leap type of statute, but it wasn't intended to protect the environment. It wasn't intended to say do X. If there's three alternatives and one is the least environmentally damaging, that's good to know. It's good to disclose that to the public and know that as a decision maker, but you might decide that the benefits of the project outweigh the environmental impacts. And so at the end of the day, NEPA doesn't require you to pick the action with the least environmental impacts, but it does require you to consider and determine what that alternative might be. So it is policy, it's not protection. So you have to, it's aimed on informed decision making by agencies is the first goal, and the other goal is public transparency. So they give folks, you and me, businesses that are regulated, an insight into the process and have an opportunity to participate and look at draft analyses and provide data before actions are taken. So there's a public transparency goal at the heart of it. Now, we're getting into, has NEPA done what it's supposed to do? And in NEPA, I think a lot of people would agree NEPA has been a good thing. NEPA has forced us to take more environmentally conscious decisions. Think about things that we weren't before NEPA was passed. Again, industrialization, a lot of economic growth, but weren't really thinking about the repercussions of all that. And NEPA helps us to focus on that. On the other hand, NEPA also can be a tool to you can analyze something forever, and so at some point an agency has to act. And so where is that sweet spot where I've done enough analysis, I know enough, and I want to go forward, as opposed to, I could do level 2, level 3, level 4 analysis. And so that's just always a tension with the statute that plays itself out in individual projects and in individual litigated cases. So NEPA, it doesn't always apply. Okay, so this is really important, and that's why I say you guys can go home early. So NEPA requires federal agencies to prepare environmental analysis for proposals for major federal actions significantly affecting the quality of the human environment. So that's a mouthful, but that really is in the whole statute the most important term. And how does that play out in practice? Well, basically, whenever the federal government does something that's discretionary, if it funds something, if it permits something, if it builds something, if it awards a contract, okay, these are typically all going to be subject to NEPA. So your presumption, if you're attached something, you should look at whether NEPA applies and come at it with a presumption that it does, but it doesn't always apply. So kind of unpacking this a little bit, when I talk about a proposal, right, I mean, what do I need? And a proposal could be something in your mind's eye, or it could be something that you put on the street for public comment or public review. And again, it's just sort of in the middle. So proposal, the problem is if we wait too long to do the NEPA, then we're going to have a sort of predetermination issue where we know what we want to do, we've outlined it, and then we're just doing the environmental analysis afterwards just as a token gesture, and we're not really going to be able to affect the decision. So that's no good. But at the front end, if I do NEPA before I really know what I want to do, what I want to propose, then it's really a non-meaningful analysis. You're analyzing everything under the sun, and it's just sort of a lot of paper, a lot of gobbledygook, and it doesn't lead to a more informed decision. So you want to do NEPA at the earliest possible time, but you got to have a sense of what it is you want to do, right? If you have a corridor where there's a lot of congestion, right? You may not want to do NEPA right away when you see a problem, but you may want to do NEPA when you propose to build a highway, you propose to build a transit line, and then you have a proposed action and you're looking at alternatives to that action. Major federal action, okay, you guys can pretty much disregard major. It doesn't have any independent meaning. But federal action, what are we talking about? The Bureau of Land Management, when it approves a fracking well, okay, on federal lands, that's a federal action. The Forest Service adopts a forest management plan. Okay, that's federal action. You have construction approvals by DOT or any other resource agency for a state highway that uses federal dollars. Okay, that's a federal action. Fish and Wildlife issues a permit to allow incidental take of a species. That's a federal action that requires NEPA review. You pass regulations for offshore wind development. Those are federal actions. They're rules. So all of these are federal actions that would trigger NEPA. But it's not everything. Okay, so for instance, what about a court decision? And raise your hand if you think a court decision, or hit on your phone, you think a court decision would trigger NEPA. And it doesn't, because again, the court is not a federal agency. Okay, what about Congress when it passes legislation? Does Congress have to do NEPA? And the answer is no, Congress doesn't have to do NEPA because, again, Congress is not a federal agency. Instead, many times Congress exempts certain actions from NEPA, or says, what kind of NEPA would be sufficient. How about actions by the President of the United States? And, most famously for the Keystone XL pipeline, requires a presidential permit to cross the boundary. That's something that's vested in the president. Okay? NEPA is not applicable to presidential actions. Now, did they do NEPA? Yes, they did do NEPA because the Secretary of State has pretty much been delegated that review responsibility. But legally, presidential decisions that left with the president, treaties, things of that nature, don't require NEPA review. What about a compelled agency action? So where they don't have any discretion. So under the old mining law of 1872, when you have a mining claim, and you discovered a valuable mineral deposit, you got a right to patent, like your house, to get fee simple patent to that claim. That's now been suspended. You can't get that anymore. But previously, when you satisfied a certain number of conditions, you automatically, by law, got that patent. Do you have to do NEPA review? And the answer is no. And this is sort of an emerging area about non-discretionary agency actions, and it's sort of, people are trying to, extend it to other areas. And the idea is that we can do NEPA review, but what's the point? Because the agency has to take the action. The NEPA review can't affect what decision the agency is ultimately going to arrive at. So NEPA review is not required if you can get into the non-discretionary action type of exemptions. What about certain like EPA actions, like under the Clean Air Act or under the Clean Water Act, or Superfund site cleanups, or hazardous waste permitting under RCRA? These things also are not subject to NEPA, and often there's a statutory exclusion. Again, the Congress stuck in, saying that basically these types of our actions are already aimed at environmental protection, and we don't need to do redundant NEPA. Some of them are created judicially under the doctrine of functional equivalence. This is another area that's sort of growing, is what the agency's doing to take its action, really covering the same things that it would do in a NEPA review. And if the answer is yes, then there's a good argument that you're just making me do more paperwork and it's not really going to lead to a better decision. So those are other areas. What about like environmentally beneficial action? And the short answer is yes. Short answer is yes. The NEPA requires you to look at the impacts, not just adverse impacts, but also beneficial impacts of an action. Why? Well, if you were going to acquire land through a land swap to benefit a species, and that might not be the best thing. There may be unintended consequences of that. You may be helping one species and harming another species. You may be compromising another opportunity for development or what have you. So NEPA requires you to look at adverse and beneficial impacts. And what about a type of project where it's just a little bit federal? So you're talking about federal agency actions. What if you're building a golf course and the golf course, the 18th hole, crossed a stream that may be deemed a water of the United States, and you would need an Army Corps of Engineers 404 permit for it? Would NEPA be triggered for that? Yeah, is a part of it. So I think the answer is yes, but then the question is, what do you analyze? And this is the answer. This is what comes under the small handles type of exception. Is the project that you're looking at just the federal action, or is it the whole action, right? So if you were looking at filling in a wetland, and there were 3 acres of wetlands that you were going to fill in for a project, but there was only 6. It was a 6-acre wetland. I mean, 3 out of 6 would be a different kind of inquiry than 3 out of maybe a 2,000-acre wetland. So how big's the project? How much of it's federalized? And basically, are you going to federalize the whole project just because of a little bit of a nexus? Yeah, there's not really a clear rule. If you look at the Army Corps of Engineers regulations, they talk about control. Does the Army Corps of Engineers have control over the project? Can they influence what's going to happen upland? And if they do have control over the whole project, a better argument that you should do NEPA for the entire project, as opposed to just the small area. So these are issues that are really a ton of factual hypotheticals that you can put, but ultimately falls under the small handles exception. Well, there's another type of issue that we come into, and it's the same type of issue. What is the action? And sometimes it's really obvious when you're looking at something. What's the action I'm analyzing? If I'm building a road, great. What if I'm building a highway from New Jersey, where I'm from, to California? Are you looking at the entire interstate highway, or are you looking at maybe there's 3 phases of the project? And this is the segmentation issue. So of course the impacts are going to be less the smaller area that you look at, and there's a very clear black letter rule that you can't segment NEPA review to avoid doing it. So if you're going to cut a project into 10 little pieces and find each little piece is insignificant, and that way you don't have to do the most intensive form of NEPA review, that's typically foul. That's not going to pass muster. But there are projects that have what they call logical termini and have independent utility. So if I have a 3-phase project that each project can basically be valuable on its own, then it's perfectly justifiable to do NEPA individually. Maybe they're separated in distance. Maybe they're separated in time. Maybe you have financing for the first one, but you don't for the third one. If they're not contingent on each other, they're not, dependent on each other for their existence, then you probably can split it up. But you always have to be thinking about the segmentation issue. And it's hard in some instances. If you're building a bridge project, for instance, and you have to, you got to have the components for the bridge, shipped in somewhere like a staging area, and it's 100 miles upstream. Is that connected to the bridge? Are those the same action? Well, staging area, wouldn't exist, but for the bridge on the other end, they're really different and they're really far apart. So, and the agencies might not come to the same decision about whether they need to be. So again, when you have different agencies, you may have some different opinions, and this is sometimes what makes it take so long. You have to negotiate all of these issues. So let's say NEPA applies. The question is, who does it? Who's responsible for the NEPA? All right, so the term you'll hear most of all is the lead agency. The lead agency is responsible for preparing the NEPA documentation. Okay, who is it? Sometimes it's really obvious, right? I'm building something on Bureau of Land Management lands. BLM is probably going to be the lead agency. But what if, for instance, I want to mine hard rock minerals that are owned by BLM, but the surface is owned by the Forest Service? So we have a split estate. Is the Forest Service the lead agency? Is BLM the lead agency? Are they co-lead agencies? And neither one of them the lead agency. Sometimes you have these negotiated through memoranda of understanding that are at a programmatic level to avoid these, but there always are these jurisdictional questions and turf issues. So you really have to, at the beginning of your project, think long and hard about who should be the lead agency and whether they're willing to be the lead agency. There's also going to be cooperating or participating agencies, and these don't have to be just federal. These can be state, they can be tribes, they could be local agencies. The difference is that a cooperating agency has control, has permitting responsibility for the project. You need their concurrence, you need them to weigh in, so they have to be part of the process. So if I'm going to take a species, I need Fish and Wildlife at the table. If I'm going to cross impact of water, I need EPA or the Army Corps of Engineers at the table. As opposed to a participating agency, one who might have some expertise and something to say about it, but not necessarily have a decision yes or no on the project. And there's always a whole wealth of opinions across agencies. And so the participating, it's important to kind of bring people in at the beginning, allow them to have their say. But at the end of the day, not everybody gets the same seat at the table. Whether or not you're going to have a permitting role really is determinative there. Okay, does the agency have to do the documentation? And this is commonly misunderstood. I mean, when you talk to a common person of the public, they think the agency goes in, prepares all the documentation, spits it out. Agencies are really busy. Okay, they're hard pressed, they're strapped for cash. Often the preparer of the environmental documentation under NEPA is a private entity. It's a contractor. It's not the private applicant, though it could be contracted by the private applicant. And there are just, a cottage industry of consultants out there that what they do is NEPA documentation. Some work with agencies all the time, some don't. And you want to have an RFP process, and they are brought on. The important thing is that the agency can't delegate its NEPA review. So it can delegate the document preparation, but the agency has to substantiate it. It has to look at it, has to review it, and has to stamp it at the end. So it can't just take a document, put its name on it, and file it. It can't rubber stamp it. It has to give it independent review, but it is not out of bounds to have a private entity do the lead on the actual documentation preparation. And of course, the private project proponent should have a seat at the table. Not always have the same seat at the table, but they should, because they know their project best of all, and they can provide data upon request. So they're often very involved, and they're often the ones who pay the price for the consultant to prepare the environmental documentation. And then the public, of course. Public comments on, we'll get to the process, but on draft documentation, provides data. Depending on what kind of sector you're in, you get a lot of repeat players. And it's important to get those feedback before an action is actually undertaken. So moving through, NEPA applies. Okay, we've got agencies that are going to do it. Now what? What do we do? Well, there's 3 ways that we can comply with NEPA, and there's actually 4 ways, but 3 that are listed here, 3 main ways. So we determine, big question, again, going back to the definition, NEPA applies to major federal action significantly affecting the quality of the human environment. Okay, the answer is yes. You have to prepare an environmental impact statement. That is the most intensive form of NEPA review. It requires more procedure. It's those very thick volumes that you see all the time, require technical reports at the back of it. Most of the regulations specify what needs to be in an EIS. All right, let's say you don't know, or you suspect it's not going to have a major effect. What you can do is called an environmental assessment. An environmental assessment is supposed to be a mini EIS. It's supposed to be a smaller, more cursory, higher 10,000-foot view that accounts for the concerns under NEPA, but you can come to the conclusion at the end that there is no significant impact, and what you actually issue is a finding of no significant impact. So when you get an EA and you get a FONSI, finding of no significant impact, then you're done. However, if you start an EA and then you determine there is going to be a significant impact, then you have to move to an EIS. So that's sort of the worst of all worlds. You don't want to do NEPA. It takes a long time. You don't want to do it twice. And so as a result, you get a lot of pressure to do an EIS at the front end, but it's not always the best thing to do. The other problem is that you get EAs that, oh, I want to do an EA. You go to a client, I want to do an EA, but they want to have the EA to have basically everything that the EIS does. So you get these EAs where the guidance under CEQ says it's supposed to be 15 pages, and the EAs actually are hundreds and thousands of pages. It looks just like an EIS, except it says EA on the front end of it. So what's the utility in that? So a lot of planning, and these look like very simple questions, but you got to decide at the outset, is this going to be a real major project where I'm probably going to end up in an EIS, or is it something where I can do something that really is truly abbreviated and I could do an EA? The other, and what most agencies do over 90% of the time, is they do a categorical exclusion. So most of what the government does are not these mega projects. They're administrative things. They're small policy things. So kind of go back to my building the road example, right? If you're fixing a pothole, you're striping the road, you're fixing vegetation on the curb line, you're putting up guardrails. That's most of the time what you're doing. You're not building a whole new interchange, a whole new highway. That's the exception. So what they prescribe in agency regulations, not just in CEQ, but in the agency regs, they have their own categorical exclusions, or CADXs, or CEs, you call them. And they specify types of activities that are, because we've done them so often, and because we've studied them, we are confident that when we undertake this action, that it's not going to have a significant effect on the quality of the human environment. So we can do a CADX, we document that CADX on a couple of pages, and we're done. CADX doesn't always apply because depending on what you do, it might be a minor action, but you might be in a special area, a special species habitat. You may be doing this action 10 different times in a concentrated area. So you have to consider whether there are, quote, extraordinary circumstances that where this CADX might not apply. But most of the time, agencies are doing CADXs. One other kind of NEPA compliance is not on this chart, and some agencies have it, some don't, most notably the Bureau of Land Management. It's called the Determination of NEPA Adequacy. I wish that more agencies did have it. It basically says that I've done this NEPA analysis for a very similar action in recent years in basically the same area. I've determined that it's not going to have significant effects, and I'm just going to basically incorporate that analysis by reference and deem that to be my NEPA documentation here. So for instance, if you're building 100 wells for a drilling prospect, and you build one well pad, and you're going to build 10 more in the same area, you do NEPA for the first one. You have to start over again. You have to start over again, start over again. Well, one option would be to analyze the whole thing, which is normally what can happen. But you also can move determination of NEPA adequacy and find what I did before is basically sufficient for doing it before. That's not so common, but again, I wish it were. So the big linchpin here is significant effect, okay? What do I mean by significantly affecting the quality of the human environment? Well, it's case by case, and you have to think about two things. One is the context. right? Where am I doing? What's the baseline? What's the background? Where am I taking this action? So again, where I take an action in a large wetland as opposed to a small one, it's probably going to have a bigger impact on the smaller one than the large one. And think about where you're taking the action. The other one is context. So how its intensity. How severe are my impacts going to be in that area? And you got to think about a whole host of things under the CEQ regs. What are the unique characteristics of the area? What special resources am I going to affect? Is there controversy about? Is there uncertainty about what the effects are going to be? This doesn't mean public controversy. It doesn't mean that it's in the media and people are getting really mad about it. But usually, if people are getting really mad about it, it's probably one of these things that are going to have some kind of effect that you're going to look at more than a cat X. So that's what significantly means. And again, that could do a whole day on what significantly means. But effects, well, there's three main kinds of effects we have to look at. We have to look at direct effects, we have to look at indirect effects, and we have to look at cumulative effects. So easy way to think about it, direct effect. What happens as a direct effect of taking this decision? If I cut down a tree to build whatever development I'm going to be building, well, the direct effect of this, there was something nesting in the tree, that's gone, or that habitat is now gone. I've taken it, it's a direct effect of my action. Okay, something that's caused by the action occurs at the same time, same place. We also have some indirect effects. Our actions, last a long time. So if I'm building a road, I have the effects of clearing whatever area and laying whatever asphalt I have, or whatever air emissions are going to come from the cars. But I also have indirect effects. So if I build a road, or I build a train or a light rail or whatever, that's probably going to attract some economic development. People probably want to live closer to where there's a metro rail station. And so that increase in economic activity and business and development would be an indirect effect. It's actually caused by the action, but it happens later in time. It's a little bit further, but it's still, the key word is reasonably foreseeable. It's not a guess, right? It's not if I drill, the world's going to blow up, right? These aren't effects that things we need to think about, but it has to be reasonably foreseeable, right? Is it within the realm of reason? Is there some kind of data? Is there some kind of evidence that backs it up where you need to be considering it? So direct and indirect. Cumulative, right? It's not caused by the action, but it happens in combination, the same area or the same location. So again, it's a very small project. If I'm drilling one well, that may not have a lot of problems, but what if I'm drilling 100 of them? So I should consider not just my one well, but I should consider all the wells in my program. So individually, they may have insignificant effects, but put all together, it's one big project that has big effects. And that kind of, again, gets into that segmentation issue. Segmentation and cumulative effects, kind of birds of a feather. Are we considering the whole action? Are we considering everything else that's going on so we really understand what the environmental effects are going to be? The other thing that I want to I want to talk a little bit more about the different levels of NEPA review, but I also want to point out that agencies can always do more NEPA. So if it's a CADX type of decision, the agency decides it wants to do an EIS, you can't take them to court, right? Just because it's going to take them more time to do it. They can actually comply with this, and the regs say that they can comply with NEPA by doing more documentation. Where agencies get in trouble is where they do a CADX or an EA, and then they get sued because they haven't done a full-blown environmental impact statement. And that's when the court can say, well, you didn't do enough NEPA review, you need to go back and consider X, Y, and Z. Now, where is that incentive? Well, the incentive is to do more paperwork, and that's where I would argue some of the problems that come with NEPA, whereas unintended consequences have been do more, do more, do more, when is that more really adding to the value of the decision? But you have to always consider that the agency can do more NEPA if it wants to. I've kind of covered this, and I tried to do it on the front end, but again, the categorical exclusion is the most common form of NEPA compliance, and there can't be unusual circumstances or extraordinary circumstances that foreclose it for a particular project. Environmental assessment, again, you can do it at the front end, but I usually caution clients if they think an EIS is going to be likely, or at least reasonably likely, just go do the EIS rather than doing it 2 times. Because again, it's very expensive and very time consuming. What if you have a significant effect and you can somehow mitigate that effect so that it no longer is significant. Can you do that on the front end and avoid doing an EIS? And this was a big issue, and the short answer is yes now. Now you can. CEQ did not like it. It actually was taken to litigation, and the courts upheld the use of what they call a mitigated FONSI, mitigated finding of no significant impact. And now there's guidance about how you use it. The only thing to be very cautious about is if you are going to commit to undertaking certain kinds of mitigation, if you're going to take you're only going to act in certain seasons to avoid breeding, breeding times, or you're going to, only work on less acreage than you intended to, or you're going to space out your effects so that all the effects are felt all at the same time. Those types of conditions have to be memorialized in the fines. You can't just commit to it and then afterwards say, I didn't really mean it, because the penalty for that in CEQs has said that sometimes you may need to reopen your NEPA analysis. So if you're going to do a mitigated FONSI, you make sure that you're able to commit to that mitigation. And as I said, I know EAs are a little bit of a misnomer. It's a little bit of a joke. 15 pages. I mean, I've never seen an EA that's less than 50, and probably I've seen 2,000-3,000 page things that are under the EA. Why don't they call it an EIS? Well, this is why, because under an EIS you have to do a little bit more process. So you have to have a formal notice of intent in the Federal Register that kicks it off. You have to do formal what they call scoping. So what are the types of effects that we care about? What kinds of resources are probably going to be impacted by the action? What are the components of my action, right? When are they going to happen? What are the local neighborhoods? What are the species who live in the area? These are all things you want to think about. But scoping is also really important to weed out the things that you don't care about, right? There aren't going to be water impacts from every project that you do. There aren't going to be underground impacts from everything that you do. So you want to really zero in on the things that you care about. That's what scoping does. I encourage my clients to do scoping, and CEQ does too, for any action that they do. Even if you're going to do an EA, just doing that kind of exercise at the front end is really, really valuable. And you want to document it. Because again, when we get to the, almost at the end here, when we get to the judicial review, it's all about what's in the record, right? Did you show your work? Didn't you get the right answer, but did you show your work? So if you're going to be doing, document on paper what your action is, the things you thought about, things that you decided aren't important, and document them and have reasons for doing that. And have, of course, when I say you, I mean the agency, but often the project applicant is the one helping the agency through that process. But scoping is very important. But for an EIS, you have to have a formal scoping process. You have to have public meetings. It has to last 30 to 60 days. You have to come out with a draft EIS. It has to be in draft. This will be it'll state what your action is, what the baseline environment is that's being impacted, what the likely effects are going to be, whether they're significant or not, and what kind of mitigation that you're thinking about doing. What is the environmentally preferable alternative? Those will all be analyzed in the draft EIS. That gets set out for public comment. And usually it has to be at least 30 days, typically they're 90, 120 days, longer than that. Final EIS, between the public comment period and the final, again, it could be years, depending on what kind of action you're undertaking, but the final EIS, the agency has to respond to the public comments. And this is probably the most important thing that the agency has to do, because often when a project is going to be challenged, your clue about what the grounds are going to be in your public comments. And how well the agency responds to those comments on the record are probably the elements of its briefs that are going to be in support of the project if it goes to litigation. So really making that record, commenting if you're a member of the public, and then responding to those comments if you're a project proponent or the agency. Really, really important step. And you shouldn't issue your FEIS until you're ready to put those responses out on the street. Then finally, you have a record of decision. The agency will decide what it's going to do, and it memorializes this action. I'm going to take X action. I've considered it through through however level of NEPA review. I've been committed to X kinds of mitigation, and that is the time when there's actually a decision that's out there and you can challenge it. Depending on what kind of action it is, that that determines how long you have to challenge it. So for instance, for highway projects now, the statute of limitations is 150 days, and that was cut down to 150 in the most recent Highway Reauthorization Act. But other types of actions you can have in a matter of years. But if you move to sue on an environmental impact statement, usually it'll be premature. You need to wait till the ROD comes out, because that's when the agency action is final. Okay, when you're doing one of these, an EA looks like an EIS a little bit, should have the same components, but what does it look like? Statement of purpose and need should be up front in your document. Again, these seem like obvious questions, but again, when you're thinking about what is my action, who is the lead agency, and what are the purpose and need of my project, those are really important questions that you have to do right, because everything flows from that. So for instance, if you're saying, I want to build a highway that's 18 miles long and goes through these cities and is in this corridor. Well, that statement of purpose and need is probably going to be found impermissibly narrow, because you're not really giving yourself a lot of latitude to consider different kinds of alternatives. On the other end, you don't want your purpose and need to be so flabby. I want to better the environment, right? I want to have better transportation. I mean, that can't be your purpose and need either, because there'd be any number of alternatives that would satisfy that. So defining that purpose and need, what is the need, what is the problem you're trying to solve, okay, and what and how are you going to go about doing that? That's really important to do up front, and to get all agencies to agree on what that statement of purpose and need is. Okay, from there you go to your alternatives, and this is what they call the heart of the EIS. So based on my purpose and need, what are the alternatives that I'm going to pursue to meet my purpose and need? And you have to have at least two. Okay, some people think you have to have 10, 20. No, you have to have two. You have to have no action. You have to consider not acting. What are the problem? What will happen if I don't act? What is the baseline environment, and what will probably, for cumulative effects, what other developments are going to happen around me if I don't undertake this impact? What are the effects of not acting going to be? And you have a proposed action, right? What do you propose to do? That's enough under NEPA. However, if you're building a linear project, a road, a pipeline, what have you, there may be different alignments that you may want to do, right? You may be able to bury it for part of its right of way. You may be able to avoid federal lands altogether. Those are the kinds of things you need to think about for alternatives. You don't need an infinite number, but you need what's called a reasonable range of alternatives. So your no action, your proposed action, and then really reasonable alternatives. You're building a road, you don't need to consider should I build an airport instead? No, you don't need to consider that. But if you're building a road, you may want to consider, should I build a smaller road? Should I build a 2-lane highway, a 4-lane highway? Those are the kinds of things that you should be considering. You want to have a description of your baseline affected environment. What is it, again, context, what is it around me, what are the types of resources that are going to be impacted, and then you look at the effects for each alternative. For each alternative, what are its effects going to be on each aspect of the affected environment, right? What's each alternative going to do for water impacts? What's each alternative going to do for air impacts? What's each alternative going to do for climate change impacts, right? Consider each alternatives and what they're going to, what kinds of effects they're going to have. And that's where you also include your mitigation, right? So different types of alternatives may have different types of available mitigation. Maybe able to build a culvert if I build a bridge, right? Or if I build an underground, maybe able to build a barrier so that I don't contaminate groundwater, things of that nature. Kind of already talked about this. Draft EIS, again, just very quickly, what happens, your draft EIS comes out, you file it with EPA. EPA has a role under NEPA to assess or basically grade the EISs. It determines whether or not there are unresolvable problems. Very rarely does it do that, but often we'll have a comment, analyze this more, we think this is lacking, and other agencies also weigh in with similar kinds of comments. 45 days minimum to review a draft environmental impact statement. If it's an EA, you don't have those kinds of hard timelines, but often the agency will give you that amount of time. And as I said, they have to look at various comments, and they have to explain why they're acting the way that they intend to act. Again, final EIS, you have to respond to the comments that are issued, and the final decision is the ROD. That's when you can take action. Supplemental EIS. So you're not done. If you finish an EIS before an agency issues its record of decision, things are always changing, right? So this process may take years to complete. Let's say you change what you want to do. Let's say you've a new development has come up. You don't want to build it over here. Now you want to build it over here, right? You found an artifact or a cultural artifact that's buried or a grave site, and you don't want to build here. You want to move it over here. Well, you haven't analyzed this alternative yet. So what you may need to do is go back and do supplemental NEPA, not start all over, but you may need to analyze that new alternative based on the change in your proposed action. Also, if there are significant new circumstances or information, not anything, but really big things that basically alter your fundamental assumptions. A lot of lawsuits are brought for failure to supplement. Most of them are unsuccessful, but you want to make sure that your record is buttoned up, that you've really considered everything. But the passage of time, basic things changing, that alone does not require you to do your NEPA again. Okay, so NEPA, favorite tool. Again, I just got done saying how it's so procedural, but it's often brought as a heart or a component of actions against various projects. And why do we care? Well, NEPA doesn't allow you to bring lawsuits. It's actually brought under the Administrative Procedure Act. So what your claim is that the agency acted arbitrarily or capriciously in undertaking this action without doing sufficient NEPA review. So they forgot to consider something. They didn't do an EIS and they should have done an EA. There was a competing model of air impacts or traffic that they didn't address or they didn't answer, and so they closed off their minds to all the other information. Those are the kinds of claims that you see all the time under NEPA. Typically, these are summary judgment cases. These are on the administrative record. There's not discovery. It's just, what did the agency do? Did the agency do enough, or did the agency not do enough? And you can do that on summary judgment. You try to convince the judge that the administrative record, which is your EIS and all those technical reports and all those things I told you to write down about your emails and your conversations, did that support your action, right? And if it does, then the courts apply what's called a rule of reason. They will defer to the agency. The agency can decide and can evidence that it did everything it was supposed to do. It didn't choose the most environmental protective action, or it chose its model over a commenter's model. Those are not reasons that your your approval is going to be overturned. That's not sufficient. The issue is always when you just didn't pay attention. You tried to bury some bad information under the rug. You didn't respond to the comment at all. That's when you get into trouble. And so really it's important to make your record, and if you make your record and the agency makes one decision, the courts will not second guess the agency and make a different decision. Usually, okay? Sometimes you read an opinion, you know exactly where it's going to go based on the first 3 lines, right? This project is taking place in an area of unraveled beauty. You know exactly where that court opinion is going, right? As opposed to the one where the agency did X, Y, and Z, they considered all factors, then it's sort of a nuts and bolts mechanical application of NEPA. Okay, what are the problems? Okay, NEPA, the hard look that you're supposed to do on your NEPA has become pretty Herculean. Again, the default is more paper, more analysis, right? There's all kinds. It's so easy to comment now. You just submit emails. You can data dump on an agency. You can give them, boxes of information, and then you require them to respond to it. I mean, this can really slow down the gunk, and sometimes that's the goal. I mean, if you delay a project enough, it can kill it. If projects rely on private money, if it doesn't look like it's going to get built in 5 years, sometimes the developer will walk away, and then that's just like denying the project. So that happens quite a bit. But you can't get so caught up in the analysis that you never make a decision. So, why do we get into, why do we get all mucked up? Well, sometimes it's the agencies. Who's going to be the lead agency? Who's the resource agency? Do I agree on things? Even within the same department, right? The Interior Department, the Bureau of Land Management manages minerals, and it's pretty much a development agency. It's supposed to protect the environment also, but it also is supposed to lease and develop minerals. Well, under Interior is also the Fish and Wildlife Service, and it's a resource conservation agency. And so the two agencies, what they are interested in may not always be the right thing. I mean, Fish and Wildlife is interested in the animals, and the BLM is interested in the minerals. And can they come to an agreement? And what happens if they can't? Right? Or who's going to force the issue? Can it be elevated in sufficient time to a secretary, or a higher level? So that's, failure for agencies to act cooperatively and timely can be an issue. I also should say, often there's no set timeline that you need to be done by. Right? Sometimes there is, but a lot of times there isn't. So you could just sit on a project or approval and you just don't issue a decision. And often it's very, very, very difficult to sue on that kind of ground for delayed action. Just usually the price of delay is itself delay. Agencies fighting with each other, federal and state, where it's not so clear where the line is. You've got issues that affect federal and state lands or interests. That could be a problem. Duplicating effort, right? So you get one agency who wants to do its NEPA analysis, then the next one does theirs, the next one does theirs, right? If it's all sequential like that, well, wouldn't it be better if everybody kind of got together at the front end, decided what their roles were, and did it one time collaboratively? That's one of the areas of reform that's big right now. But duplication of effort and not doing it at the right time at the same time can really delay. And again, the project can take thousands of pages and over a decade. So, are we on the right track? Yeah, I mean, these problems, you see them all the time. President Obama, since he's been in office, and his predecessors too, have issued all kinds of executive orders. Most recently, there's a federal implementation plan for NEPA reform. How can we get our agencies on the same page faster? How can we make smarter decisions and do it with less time and money? And those are being implemented, across the government now. But what are the kinds of reforms that we're looking at? Well, categorical exclusions. Again, we use them a lot, but do we use them all the time, or when we should? Department of Transportation put out a survey and asked for new categorical exclusions that they should be considering. Congress told them to do that. And then at the end of their 6-month survey, most of the answers were things that were already in the statute and regulations that people just didn't know existed. And this is true. I mean, this is out there. So really looking at CADXs, and are we using them to their maximum extent? Looking at planning and NEPA. Am I considering where my project is going to be built when I'm doing a planning? If I'm a BLM, if I have a land management plan, right? I don't have to wait for the actual mine or oil well or platform to be proposed. I should know sort of where development is going to be concentrated, and can I analyze that from a programmatic level and do a lot of that work, so that when proposals are actually made, they're made in areas that are less resource sensitive. So planning and NEPA, coordinating that. I said concurrent reviews, deadlines. Really important. CEQ encourages deadlines, but they aren't ubiquitous. So one of the things I advise when you're getting into a beginning of a process, set deadlines. I don't care what they are, 2 years, 6 months, but come up with a deadline, and so everybody knows about how long it's going to take, and then everybody has a goal to shoot for. In rare instances, there are penalties. Actually, in transportation, you can DOT can penalize a sister agency, actually assess money when they don't render a project decision in time according to the set schedule. And they have regulations, and Congress told them to do this. That's not a prevalent model in the federal government, but it's just another way to kind of get at this issue. Again, thinking about things early, giving states a greater role. Can states do the NEPA process? There are pilot programs out under different statutes for states to do the NEPA analysis, because they're right there where the resources are. Can they take a greater role and take some of the burden off of overtaxed federal agencies? Can we reduce the time for litigation? Can we expedite it? And accountability. This is really a big thing. They call it dashboards, right? If I tell the public what it is I'm doing, how long I expect to be doing it, and I give progress updates, that gives people confidence that there's actually action being taken and we're making progress towards the end. It's not just in a black box. I sort of talked about this, but that's the last thing I have. On tiering, I said that you don't need to start all over again for determination of NEPA adequacy, but there's also other ways that this concept manifests itself. So again, if I've done a NEPA for a big programmatic thing, for a land use management plan, right? If I'm BLM or I'm Forest Service or I'm, what have you, and I have a plan for a set area of land. I say oil is going to be over here, recreation is going to be over here, this mineral is going to be developed over here, and I analyze all of that. I can take the product of that analysis and apply it when it comes time for me to authorize an individual lease or an individual project. I don't need to start all over again. So that's called tiering, where you're actually taking a big programmatic type analysis and then you're winnowing it down to individual projects. You have to look at the project-specific impacts when you do that NEPA, but you don't have to start all over again. You can kind of take some of the baseline, some of the cumulative impacts analysis, and just incorporate that into your next NEPA document. So again, best practices, you should stop and think, again, as an agency, but it doesn't require you to take the most environmentally preferable action. The idea is just that if you know what the impacts are, you will try to minimize the impacts of your actions. Build a record. Don't just assume that because we talked about it, it's going to be featured, because 6 months from now, a year from now, we might not remember that conversation. And if the judge can't see that conversation happened, it's not going to help you. Analysis are for NEPA, they're project or plan specific, but they're not in a vacuum. Look at what's out there, look where you're undertaking the action, what kind of things have been analyzed before, and try to make use of existing good literature analysis that's out there. Don't brush issues under the rug, acknowledge them, face them. If you have a problem with your project, you can try to alter it. But again, at the end of the day, if you have an impact, that's not a problem from a NEPA standpoint. And continue to follow agencies for streamlining examples. It's happening sector by sector, the mining sector, the geothermal sector, the transportation sector. You're seeing all these kind of piecemeal bills come out of Congress. The president has put out government-wide types of edicts, but really follow these. And a lot of good ideas about there. How about NEPA work without, repealing the statute or having major amendments to the statute itself. So that's NEPA and longer than I wanted to do, and I hope I didn't cut you off, Jane.
That's okay. I'll just talk really fast.
That's fine.
I think we'll move right along.
Okay,
and
great.
I do have some questions online, but I think I'll reserve them until the end.
Okay. So someone technically is going to have to pull up my PowerPoint. Okay, onward and upwards. Okay, so I think Jane did a really good job of laying out how NEPA really is a process-based statute, not a protection-based statute. One of the analogies I always like to give people is that if the National Park Service wanted to pave over the Grand Canyon, it could. It could do the world's biggest EIS, and then it could choose to pave over the Grand Canyon if it wanted to, as long as it had crossed all the I's and dotted all the T's and come out with an environmental impact statement. So the ESA, which I'm going to talk about, has a lot of process in it. There's process for the wildlife agencies, there's process for federal agencies taking agency action, but it is also a statute with substantive obligations that are imposed on federal agencies. So process notwithstanding, at the end of the day, the ESA, the Endangered Species Act, really is about protection of endangered and threatened species. And the ultimate goal of the statute is not just to list species and have them on an ever-growing, ever-expanding list of endangered and threatened species, but actually to get them to the point of recovery, to get them to the point where the protections of the statute are no longer needed. I probably should have put up a slide here, speaking of the historical context. As Jamie mentioned, the ESA was part of the slew of environmental statutes that came out in the early 70s at a time when Republicans and Democrats were really trying to one-up each other as to who could be the more environmentally protective. And certainly, incidents like the Santa Barbara oil spill or the Cuyahoga River, like literally catching on fire, captured public attention. But another issue that really captured public attention and something that really brought attention to the fact that we were losing species was the publication of Rachel Carson's book, Silent Spring, about the effects of pesticides such as DDT on species of wildlife. And there was a time when it looked like the bald eagle, our nation's avian symbol, might go extinct. And it was one of the flagship species on the Endangered Species Act. People really got an awareness in a very visceral way that birds were disappearing and that human activity had everything to do with that. So, fortunately, we don't see a lot of rivers catching on fire these days. Many of our nation's environmental statutes really have led to a huge improvement in environmental quality. Unfortunately, the situation for biodiversity, both at a national and a global level, is not improving, and in fact is getting much worse. So what I wanted to start out with, before I launch into a discussion of the process and substance of the statute itself, is why does it matter? Where are we? This is the cover of this book by Elizabeth Colbert is something that came out last year. And I commend it to everyone. It's certainly not cheerful, uplifting reading, but something that's really vitally important to understand is that we are in the middle of a human-caused crisis. It's the sixth mass extinction. The natural background rate of species extinction, which just happens as a natural process of evolution and glacial rates of environmental change, is 1 to 5 species a year. We're now at a rate of about 1,000 to 10,000 times that rate of extinction, and it is human-caused. The IUCN, the International Union for the Conservation of Nature, it's an organization of scientists, and they have a very science-based, data-driven process by which they evaluate the extinction risk of species. So the Red List is a mechanism globally to identify those species that are extinct, critically endangered, threatened with extinction, vulnerable, all the way down to data deficient. We just don't know enough information. They've only assessed 3% of all described species to date, and globally they have found that 38% of all assessed species are threatened with extinction. Now, I think one of the important things to realize here is that 3% of described species, the described in there is very important because we don't actually have a handle on how many species there are in the world. For example, marine species, only a tiny fraction of all species that are in the ocean are even known to science and have been described in any kind of systematic way. So, you can read the percentages there for yourself, but those smaller bullet points are those species that the IUCN has determined are either extinct or threatened with extinction. So I don't know how clearly this graphic is going to come across, but if the color category, everything from black down to the yellow on the sort of the left-hand side at about the 7 o'clock position, those are all the species that they've assessed that they believe are in trouble for a variety of reasons. Another resource is the World Wildlife Federation's Living Planet Index. This is a statistic that has a great deal of meaning to me. What they've looked at is essentially like bulk numbers, like count them all up, how many elephants are there, how many rhinos are there, all the way down to how many salamanders are there, just as a sheer quantity. Population sizes of vertebrate species, i.e. absolute numbers, how many animals are there, have declined by 52% in the time period 1970 to 2010. I was born in 1968, so this is my lifetime. There are half as many animals, vertebrates, that WWF has assessed on the planet as there were when I was born. And you can see on the graphic on the right-hand side what are the primary drivers of this massive diminution in biomass on the planet. And obviously a huge part of that is direct exploitation. There's only so many elephants you can kill to turn into ivory chachkas before the populations crash. But I also really want to point out the habitat part, because that's something that we're really going to look at with respect to the Endangered Species Act, and that's, you know, in their analysis responsible for 30% of this just absolute, you know, reduction in half of the animals that were part of this analysis. So let's talk about the Endangered Species Act. It's, as I said in my very beginning intro, it's a short and sweet statute. Highly recommend reading it. It doesn't take very long. And one thing that I wanted to put up here, in addition to the statutory citations, are the regulations. And as you know, Jamie mentioned in his slide with respect to sources of law, you know, environmental law is very much an administrative law field. In fact, what I always tell students when I'm teaching classes is I would almost rather see students take administrative law over environmental law if there's some kind of a conflict. I think it's a hugely important part of what environmental legal practitioners do, whether they're litigators, whether they're working as agency counseling agencies, whether they're in the private sector counseling clients. If you don't understand administrative law, you're really not going to get a grasp on environmental law. And another thing that I will say, and as I have said to my students in classes I've taught before, I think law schools often, at least it was certainly true in my legal experience, my legal education, and others that I hear about, I think the casebook method is exactly the wrong way to teach environmental law, because it's taking sort of the back end analysis and assuming that that's how the sausage gets made in the factory up front when agencies are making decisions, when so what I always recommend that students do is leave the cases for the very last. You have to start with the statute. You have to go to the regulations. As Jamie mentioned, you have to go to agency guidance. That's what you really need to understand. And certainly if you're going to be a litigator, you have to get a grip on the case law as well. But in terms of how decisions are made under these statutes every day, you know, you have to start with the statute and the regulations. So starting with the purposes, why did Congress enact and President Nixon sign the Endangered Species Act? In putting up these statutory purposes, one of the points I really wanted to emphasize is that the Endangered Species Act is not about species in a vacuum. It's not about species in a zoo. It's not about Martha the last passenger pigeon, you know, dying in the zoo. It's really, there was a fundamental understanding that you cannot protect biodiversity. You cannot protect animals and plants without protecting their ecosystems and their habitats. It's simply not possible. So even though it's called the Endangered Species Act, it's really the Endangered Species and their ecosystems, Endangered Species and their Habitats Act, because you cannot separate species from their habitats. I mean, sure, you can put species in a zoo, and you know, the zoos can provide really important conservation benefits, but unless you have habitats in the wild where those species can live out their natural lives, they're really not, you know, they're not going to survive in the wild without habitat protection. The third bullet point here, I'm not really going to spend any time on it in this presentation, but I'm really going to focus on the domestic aspects of the Endangered Species Act in the U.S. But one role that the ESA plays is the implementing legislation for a number of treaties and conventions that the United States has ratified. And as I'm sure many of you will be aware, treaties and conventions often are not self-implementing. They're not self-executing. Once, you know, the U.S. signs on to a treaty, it has to have domestic legislation to implement that. And so the ESA does play a really important role as the domestic way in which treaties to which the United States is a party are implemented in the United States. But I'm really not going to focus on the international aspects in this talk. So another very interesting thing about the Endangered Species Act, and as it's written in the statute, is, you know, all federal agencies are creatures of, you know, the executive branch, and their mission is to implement one or more federal statutes. The ESA is an extremely interesting statute in that it creates co-equal obligations on all federal agencies to implement the Endangered Species Act at the same level as their primary implementing statutes. So whether it's, you know, the Federal Highways Administration implementing highway law, or whether it's the BLM implementing federal lands management, the ESA is a co-equal obligation. It is not a lesser obligation. It is a co-equal obligation on all federal agencies, and they need to use those authorities, whatever their statutes are to further the purposes of the ESA. A key term I wanted to point out here, because it appears all throughout the statute, including in this obligation language, is that, you know, conserve or conservation, as I mentioned before, is to use every means at the agency's disposal to bring species to the point where they no longer require ESA protection. So, for example, when the bald eagle was sufficiently recovered to the point where it no longer qualified for ESA protection, it was delisted. It is no longer protected under the ESA. So that is the ultimate goal. Certainly, it is still an aspirational goal, and most of the species that are listed under the ESA have not reached the point where they can be delisted because of recovery. But, you know, the bald eagle is not the only example. And so the ESA has actually been a success story for a number of species in that protections were needed for a while, but recovery got to the point where the protections of the statute were no longer needed. But that is the ultimate goal. It's not just to have a list, but it's actually to list species, protect them, get them off the list because they have recovered. So let's get into some of the nuts and bolts of how the ESA works. These are the 5 sections I wanted to touch on in this talk. Section 4 is a section that applies to the agencies that implement the ESA, that being Fish and Wildlife Service under the Department of the Interior and National Marine Fisheries Service under the Department of Commerce. So Section 4 sets up their obligations in terms of listing species and designating critical habitat. Section 7, which we'll definitely spend some time talking about, is what all federal agencies have to do with respect to conserving listed species that may be affected by federal agency action. Section 9 is about obligations on everyone. Federal agencies, state agencies, private individuals, the prohibitions on take of species, and we'll talk about that briefly. It's an extremely broad definition of what is prohibited by the statute, and there are, you know, both civil and criminal penalties that attach to violations. Section 10 we'll talk about briefly. Permits for incidental take that can be obtained by private parties on private land, and I do want to get to judicial review very briefly.
And just if you take nothing away from this, the difference between NEPA and ESA is, and a lot of people don't understand this, ESA applies to you in your backyard, in your house. NEPA, if you're not a federal agency, you're not doing NEPA, but ESA will reach right to your dinner table. And it's a,
right.
You're not eating endangered species.
Yeah, let's hope not. Okay, so let's talk about how species get on the list of endangered or threatened species. Section 4 of the ESA, 16 U.S.C. 1533, and the regulations are at 50 CFR Part 424. There's a really critical difference. Often people just sort of lump E&T together, endangered and threatened species, but there are critical differences between the protections that attach to endangered and threatened species. So an endangered species is one that is in danger, that's a typo, I should say, of extinction throughout all or a significant portion of its range, whereas threatened is likely to become an endangered species within the foreseeable future. Another typo there, sorry about that. So, you know, how a species becomes, is categorized into one or the other is something of an art. It's certainly a determination that agencies will largely get deference when they're evaluating the scientific evidence. And of course, it's very case by case. So it's really, you know, it's hard to say, you know, in a particular species case, this one, you know, definitely will get slotted into endangered or definitely get slotted into threatened. But the really significant difference comes, Section 9 take prohibitions only apply as a blanket matter to endangered species. So the really significant legal difference between endangered and threatened comes at what level of protections do threatened species get. And the theory being threatened species, there's more time. You know, we have more of a lead time before they really hit the brink of extinction. So therefore, there's more flexibility that is available in terms of the take prohibitions and the regulatory conservation measures that are going to need to be taken for them. So Section 4D of the statute allows the Secretary of either Interior or Commerce to establish a rule for threatened species that's tailored to that species' needs, circumstances, to say these take prohibitions will apply and those will not. Interestingly, Fish and Wildlife Service a number of years ago promulgated a blanket 4D regulation. So it essentially flipped the default switch. Instead of saying threatened species get no protections under Section 9, it promulgated a regulation saying threatened species get all the protections under Section 9 unless we say otherwise. National Marine Fisheries Service, on the other hand, is the opposite way. Threatened species under NMFS's jurisdiction require a 4D rule in order to get the protections of Section 9 with respect to prohibitions on take. And that is actually sort of a developing area of the law. We are now seeing more species come out from Fish and Wildlife Service that are listed as threatened with very extensive 4D rules saying, this is take, this is not take, and really being quite specific as to particular species and particular activities that may affect them, as opposed to the Fish and Wildlife Service's former practice of just saying, well, if you're threatened, really it's the same as endangered. In terms of process, the species can get put on the list because either the Fish and Wildlife Service or the National Marine Fisheries Service determines they warrant listing. But there is also a citizen petition process. Any person can submit a petition to the Secretary to say this species needs to be listed. Here's all the information supporting that. So the statute sets up a very process-based timeline for that. When a citizen or organization submits a petition to the Secretary is statutorily required to make a threshold decision on that petition within 90 days, caveat to the maximum extent practicable, which can mean essentially, well, ideally it's 90 days, but if we have a lot on our plates, it can be longer than that. But that 90-day finding is supposed to be made only on the basis of what's in the petition. This is not the time when the Wildlife Agency goes out and starts doing its own research. This is not when the Wildlife Agency goes out and starts contacting state wildlife agencies or other scientific bodies that may have information on the species. The standard here is, would a reasonable person reading this petition believe that the petition action may be warranted? So it is not meant to be a really fine discrimination. It's really meant to be, does it pass the straight face test? Does the petition give us enough information to say we should really take a more in-depth look? So at the 90-day stage, the agency publishes a finding in the Federal Register and says either thumbs up, we've made a positive 90-day finding and we're initiating a status review and we'd like your comments, or thumbs down, negative 90-day finding, we're done here. This really doesn't give us any information to indicate that listing is warranted and further work is necessary. So this opens it up to public comment, and the Wildlife Agency will contact directly state agencies, international bodies, scientific bodies, and do its own due diligence. It will search its files. It will, try to pull together all the scientific information, and as part of the status review, it will it will put together a status review, which will go to peer review and then publish at the end of this process what's known as a 12-month determination. What's interesting about that 12-month determination is that 12 months is counted from the time the petition is submitted. So even though the 90-day deadline itself is not a hard deadline in that it has that wiggle room of to the maximum extent practicable, the 12 months is a hard deadline. That is a mandatory, non-discretionary duty to make that 12-month finding by the 12-month date, and that is enforceable through a missed deadline suit. A plaintiff can file a suit saying you missed the deadline, and the court will say, yep, you missed the deadline, here's your deadline. So in that 12-month determination, once the agency has really taken an exhaustive look at all the information, the next cut it makes is, okay, thumbs up, this species warrants listing, here's our proposed rule for comment. And it's supposed to do a proposed rule to designate critical habitat at the same time. Certainly doesn't always happen. And then there's another round of public comment. It can also say listing is not warranted, in which case it publishes its finding, and that is a final agency action that's subject to review. Another thing it can do at the 12-month stage is say that this species listing is warranted, but it's precluded by higher priority listing activities. So what the services will do is essentially categorize and say, this one really needs protection sooner than the other one. So the other one may the one that is warranted but precluded will go to a candidate list. So there's a list of species that are protected as threatened or endangered. There's a list of candidate species that receive no protection but are in the pipeline to get a determination at some point. So once the 12 months is done, assuming it's a proposed rule, there's been public comment, the secretary then has, it's basically a 24-month finding. 24 months from the date of the original petition, the final decision has to be made. And that could be, we did a proposed rule, but we've changed our mind. We are not going to list the species because we got new information, or places where the species is found, maybe private parties or states have entered into candidate conservation agreements. Essentially, there's now a heightened level of protection for the species that either wasn't present before or wasn't finalized, but now the species has enough protection that it doesn't need listing. And the secretary can also choose to list the species, in which case there has to be a regulation published. Critical habitat, which I'll turn to in a second, is supposed to come along with that. And of course, at the final determination stage, that then becomes the agency's final action, which is also something that can be subject to judicial review. So that's how the species get on the list. I want to talk briefly about why does the species get listed. The statute provides these 5 listing factors. Habitat overutilization, which could be something like overfishing, disease or predation. So those can be independent biological factors that really have nothing to do with human activity, but they can cause species to become endangered or threatened. And a very salient example of that you may have heard of is white nose syndrome, which is a fungal disease affecting cave-dwelling bats that was most likely brought over on some cavers' equipment from Europe. It's a fungus that occurs in caves in Europe, but European bats aren't bothered by it. American bats have been killed in the millions by it. And so very recently, the service finalized a listing of the northern long-eared bat because its numbers has essentially dropped like 99% in its core range in the last 6 years because of white nose. So certainly not anyone's fault, not intended, but nevertheless, the statute provides that these biological issues can become reasons for invoking the protections of the statute. Factor D is very important, the inadequacy of existing regulatory mechanisms. In the United States, going way back in our system of common law, states have primacy in wildlife management. So unless there is some federal reason to manage a species, such as through the ESA, the default position is states are the one managing wildlife within their borders. So that's why if you're a hunter, you have to go get a hunting license, or if you're fishing, you have to go get a fishing license. So one of the factors that the service is required to evaluate is what regulatory mechanisms are already in effect that may protect these species. And as with NEPA, there are state ESAs, like mini ESAs. Most of them have almost no legal protection for species in terms of protecting them from habitat degradation and similar factors. Many of them are essentially about commerce, like regulating taking and commerce of these species. So, but there can be a number of different regulatory mechanisms that are have to be evaluated. And one thing that I'll throw in here that I didn't mention at the beginning is, I mentioned that the ESA has an international component. Fish and Wildlife Service and NIMS have to consider petitions to list species that are not found within the United States. So they could be on the high seas, they could be in a foreign country. The ESA is not specific about that. And there actually are a number of species that are listed on the ESA that are, wholly foreign species, for example, tigers or elephants. So one of the factors that the service will look at in its listing analysis is, do foreign governments or international treaties provide sufficient protections for these species, or do they require ESA listing? And that can lead to some, pretty straightforward statements in the Federal Register that maybe the State Department might have an issue with in terms of the diplomacy of these statements. But for example, the National Marine Fisheries Service recently came out with, relatively recently, came out with a proposed rule to list Harrison's dogfish, which is a kind of shark that's only found in Australian waters. And it's been subject to overfishing, both as a result of bycatch and direct take for, turning its liver into shark oil. And the Australian government actually now has regulations in place banning the direct take of the species. And so when the species was petitioned for listing, one of the things that National Marine Fisheries Service had to do was put itself in the position of judging, are these measures that the Australian government has taken, as a sovereign nation, are those adequate to protect the species? And NIMS actually said, no, they're not adequate because this statute that the Australian government has enacted is only in place for 5 years, and that's great, but that's not enough time to rebuild this species. So you have a very interesting dynamic where, a U.S. domestic agency is passing judgment on the adequacy or lack thereof of, sovereign nations' efforts at species protection, but that's what they're required to do. And E is just a catch-all for everything else, other natural or man-made factors. So a listing determination to list a species can be made on any one or a combination of all of these factors. So you don't have to have some sort of 3-to-2 evaluation. It could be, it's going to be on a case-by-case basis, but this is a set of factors that the agency has to examine. As a separate requirement, they do have to take into account efforts of state and foreign governments. But what I really want to emphasize with respect to the listing determination is the statute requires that it be made solely on the basis of the best available scientific and commercial data. So there's a couple of important points to emphasize here. One is it's available data. So you don't have to have conclusive data. A lot of these times, science is as an iterative process. You're going to asymptotically approach conclusiveness, but it's hard, from the scientific perspective, ever to say something is absolutely 100% guaranteed. So the statute mandates that the agency act, even if it doesn't have perfect data, and it doesn't have to go out and create the data. It has to evaluate the data that exists in the world. So it really has to make a balancing determination, using our best scientific judgment. What does the balance of the data say? The other important point in here is that it has to be solely on the basis of the best available commercial and scientific data. Commercial here means essentially, for example, if you're catching fish, how many fish have you caught? That is commercial data. Economic impact cannot, by statute, play a role in a listing determination. So, for example, taking the seminal case of Tennessee Valley Authority versus Hill, where we're building Tellico Dam. The dam is almost built. We have spent millions and millions of dollars to build this dam, but oops, surprise, here is the snail darter. And if you shut the dam, you're going to cause the snail darter to go extinct. In terms of the listing decision that was at some point made, assuming that the service knew that the Tellico Dam was being built, it couldn't say, well, we're not going to list the species because we've already spent millions and millions of dollars, which will be completely down the drain if, the listing goes forward. So the economic impact of a listing cannot be a factor that plays into the determination. It's supposed to be solely a scientific determination. Another part of Section 4 that's very important is about designating critical habitat. Circling back to what I said at the beginning, Congress understood you cannot protect species in a vacuum or a zoo. You have to look at the habitat harms that they are facing and protect enough habitat that they can survive and recover. So concurrent with listing, although it's often something that is delayed after listing, the services are supposed to designate critical habitat. And this is very specifically areas that are occupied by the species essential to the conservation, i.e. survival and recovery, which may require special management. They can also designate unoccupied habitat. So, many species will have suffered a contraction of range. That's part of why they're endangered. But maybe there's habitat there that's still suitable for them, even if they're not found there. Potentially, they could either naturally spread to those areas or be reintroduced to those areas. So we have to take a look at, are there unoccupied areas that warrant protection? There's an economic consideration that does come into this stage. The Secretary can determine to exclude areas from critical habitat designation if essentially the economic costs of that designation would outweigh the benefits. There also has to be a national security impact analysis that goes along with that. You know, should we not designate critical habitat on, for example, an Army base because that would interfere with the training mission of the Army at that base and therefore potentially negatively affect national security concerns. There's also a couple of reasons why the service might determine not to designate critical habitat. It can get completely out of the obligation to designate critical habitat if it finds it would be not prudent. This is an exception that's meant to account for the fact that, you know, people being who they are, if you tell someone, here's where you could find this really rare plant, they might go dig it up, they might go destroy it, they might go collect it. So there have been not prudent determinations made where the fear is that identifying on a map where those species are might lead people to go destroy them, collect them, you know, want to own the last one of whatever it is. The service can also make a decision at the time of final listing that critical habitat is not currently determinable. We don't have enough information because we have to go into this really specific analysis of, you know, what is it about the habitat that makes the species need to be there? What are the primary constituent elements of this habitat? So it's a really, you know, it's a lot of information and it's a lot of analysis the agency has to do. So at the time of final listing, if critical habitat is prudent, they can say, we need another year to get it done. And so that's the not currently determinable exception that gives them an additional year to get that done. Also under Section 4, again, the whole goal of the statute being to recover the species, the wildlife agency needs to write a recovery plan. This is something that it usually does in coordination with other agencies. It may have a role to play with scientific experts, with conservation organizations. The recovery plan, it's a roadmap. It is meant to set like criteria, like if we can get our bald eagles to this many breeding pairs in this many states, then we will know that the species has recovered to the point where it no longer needs protections of the statute. So, and it may also say, you know, we need to accomplish these tasks, we need to address these factors that made it qualify for listing in the first place. The thing to know about recovery plans is they're not actually binding. They're a roadmap, but it's really an aspirational set of goals. So it's not going to say, you know, a federal highway agency, you have to go out and purchase, you know, this amount of mitigation land or whatever. It's not going to say, you know, BLM, you are no longer allowed to lease areas where this particular critter might be found. So it provides a lot of goalposts and guidance, but it doesn't actually result in legal obligations on anyone. Another thing that the services are meant to do is conduct 5-year status reviews for every species, you know, 5 years in, 10 years in, 15 years in, here's how we're doing, here's the progress that's been made or the lack thereof. So these are all obligations that are on the wildlife agencies managing
They're
the species.
supposed to do. But
That they're supposed to do.
A lot.
You know, certainly with respect to recovery plans and status reviews, those are the kinds of things that tend to get delayed because of, you know, workload and budget issues. And those are also things you can sue over when they haven't done them. So moving on to Section 7, yeah.
Just a quick question. Could you clarify like jurisdictional boundaries between like NOAA and fish and wildlife species or geography?
You know, certainly the general rule is that Fish and Wildlife Service has terrestrial species and NIMS has marine species. There are some instances where I think basically at some point a long time ago they sat down in a room and they said, okay, Fish and Wildlife Service, you've got walruses and polar bears, even though those are marine mammals, and, you know, National Marine Fisheries Service, you have quails and dolphins, you know, and there are, so it's generally divided as terrestrial versus marine. There are some areas where they just had to choose who's doing what. There are some species where they actually share jurisdiction. For example, with sea turtles. Fish and Wildlife Service has jurisdiction over sea turtles nesting. National Marine Fisheries Service has jurisdiction over sea turtles in the water. So they will publish joint regulations. So for example, the agencies recently came out with a joint proposed rule to take green sea turtles, which are currently listed globally, divide them into 11 what are called distinct population segments, and list 3 of them as endangered and 8 of them as threatened. So that's a joint regulation. with respect to loggerhead critical habitat. They had done the same thing for loggerheads. They took the global population, sliced and diced into distinct population segments that may require different management or may face different threats depending on where they are. And they came out with 2 sets of regulations. Fish and Wildlife Service designated critical habitat for loggerheads on land, and National Marine Fisheries Service designated critical habitat for loggerheads in the ocean in U.S. territory. There are some places where they share responsibility. There are also other instances where, for example, you have anadromous salmon and they live in the ocean and swim upstream to breed. NIMS has those. Generally, if, when in doubt, start with the agency, look at the website. And there have even been some where they've kind of played hot potato and passed them back and forth, like, a petition to list like a saltwater marsh minnow fish, I can't remember what it was, originally went to NIMS, and NIMS was like, that's going to Fish and Wildlife Service. So, I'm sure there's some, negotiating that can still go on depending on what the facts of the particular species are. Another thing I'll mention about critical habitat, it will become important in the context of Section 7. This is, it's a common misperception on the part of the public or parties that critical habitat can result in land restrictions on private activities. And critical habitat, when we talk about Section 7, only comes in as a consideration in a Section 7 consultation. So when critical habitat is designated, it has no effect on private parties at all. It does not result in any additional restrictions on their property unless they need a federal permit and they have to go to an agency for a federal permit, in which case the agency will have to consider critical habitat. Another thing I will mention about Section 4 before we move on quickly to Section 7 is that I mentioned that species that are entirely foreign or on the high seas can be listed under the ESA. However, critical habitat is only designated within those land areas and water areas under the control of the United States. Again, because it's an obligation inherent on federal agencies to consider impacts on critical habitat. So we are not going to be designating critical habitat for a hammerhead shark in Indonesian waters. That's just simply not going to happen. So quickly moving on to Section 7, this is really the heart of the ESA and really where the impacts to federal agencies, state agencies, and private parties is felt. 7A1, you can see it right here. It reiterates again that federal agencies have a duty to use their authorities. Courts have basically found that they don't have their duty to use their authorities in any particular way to conserve species. They just have to be doing something. So, all federal agencies need to have some sort of plan where they can use their statutory authorities to do good things for species. But 7A2 is really where the rubber hits the road with respect to the intersection of Section 7 with all federal agency actions. So the fundamental obligation of Section 7A2 is to ensure against jeopardy. So any federal agency has to ensure that its actions authorized, funded, or carried out are not likely to jeopardize the continued existence of an endangered or threatened species or result in the destruction or adverse modification of critical habitat. And the regulations implementing Section 7 are found at 50 CFR 402. Section 7 was interpreted all the way up to the Supreme Court. The sort of the high watermark of ESA litigation out of the Supreme Court was the seminal case of Tennessee Valley Authority versus Hill, where in fact the Supreme Court said that the statute means what it says. It doesn't matter if you have dumped, $1 million billion into the construction of this dam. Once you find the fish, and the Fish and Wildlife Service has found that, when you shut the dam becomes operational, the fish will go away, then you can't build the dam. So the language from TVA v. Hill will be quoted in pretty much any ESA case you want to look at. And basically the Supreme Court said, Congress meant what it said. Agencies are to place the conservation of listed species above their primary mission. So whether your primary mission is to build a dam or to build a road or to develop minerals on federal lands or to cut trees or manage forests on federal land, that gets trumped. You may have Congress gave you a mission, but that mission is trumped by your obligation to avoid jeopardy to listed species. Lots of great language in TVA v. Hill, which I will not read for you, but it's, again, a decision I commend to your attention as the high watermark of ESA-friendly litigation cases. Yes. So this is the fundamental obligation of an agency is to avoid jeopardy, which is essentially, are you going to appreciably reduce the likelihood of survival and recovery of the species in the wild? Or in the context of critical habitat, and this is really where critical habitat comes into the statute, is in the Section 7 consultation obligation. Are you going to destroy it or adversely modify it in such a way that you've diminished the value of that habitat for the species survival and recovery? And getting back to the procedural versus substantive, this section really has both procedural and substantive obligations. Obviously, this is the no jeopardy, no destruction, or adverse modification is a substantive obligation that applies to all federal agencies, but there's process that they have to undergo to prove that they have fully complied with their duty. Much like in NEPA, I mean, this is very similar kinds of requirements. When are you going to trigger this duty to consult? When you've authorized, funded, or carried out an action by approving a permit, by promulgating a regulation, by giving money to someone else to do something. The real hinge here, though, is you have to have discretionary federal involvement or control. And the case citation here, National Association of Home Builders versus Defenders of Wildlife, in this case, the Supreme Court found that when the EPA evaluates a state program under the Clean Water Act for implementing the Clean Water Act at a state level, much like the Clean Air Act or other federal laws, states are given the opportunity to design their own programs to implement those statutes at the state level, essentially meeting the floor of federal regulations, and EPA has an approval process that has to go through. And what this case was all about was, does EPA have to consult with the wildlife agencies on the potential impacts to listed species of approving a state's application to take over the Clean Water Act program? And what the Supreme Court found was, no, it does not, because essentially what the Clean Water Act provides is a checklist. If the state checks off these 9 boxes, its regulatory program meets these 9 criteria, then EPA has no discretion. Like, assuming the boxes are checked, then EPA must approve that state's Clean Water Act program. And therefore, there's nothing it can do to condition that approval in a way that benefits species. So where you have non-discretionary federal agency actions, like if X happens, then Y, such as Jamie was talking about the former way that mineral patents were issued, if X then Y, it automatically happens every time, there's no need to consult because you can't do anything good for species, in your statutory or regulatory discretion. So, that's really the first cut. You need to know that there's a discretionary ability by that agency to condition its action, authorized, funded, or carried out in a way that will benefit species. Another thing that's very important to understand about when the obligation to consult is triggered is the question of what's your action area. If you're, for example, the Army Corps of Engineers and you're issuing a Section 404 permit under the Clean Water Act to a surface coal mine that is going to mine through or otherwise, deposit spoils of mining into waters of the United States, then your action area is not just where the mine site is, but what happens downstream if there's listed habitats, critical habitats or listed species downstream. So agencies have to look, quite broadly, not only at, what's the specific area that's going to be affected by our action, but what happens downstream, what happens elsewhere. So, it's really meant to be a broader, more, ecosystemic look than just, okay, we're building a highway segment and it's going to be in this one little place. This is essentially a chart of how the Section 7 consultation process goes. So this is what all agencies have to do. First, their first cut is, are we going to affect species or are we not going to affect species? If they determine no effect, they're done. They don't have to proceed with an ESA consultation as long as they have made that determination that our action will not affect listed species, we're done. They will often get in touch with the services to make that determination. They will often request assistance of the services to say, here's what we're doing, here's where we're doing it, can you please send us a list of listed species and or designated critical habitats, and then they compare it and they say, we're clear, there's nothing here, there's no species that are going to be affected. Or they can maybe even take it a step further and say, okay, we know these species are here, but they're not going to be affected one way or the other because of how we're doing our project. And if they've made that no effect determination, they're done. They have no further obligation under ESA Section 7. If they make a may affect determination, importantly, it could be a positive beneficial effect or a negative effect. They have to proceed to either what's called informal or formal consultation. So if they've made that may affect determination, they have to move forward. Informal consultation is essentially the process that describes any level of communication between the action agency and the wildlife agency. So it can be phone calls, it can be letters, it can be emails, it can be whatever the communications process is in a very informal way to get to either what's called an NLAA, a not likely to adversely affect, or likely to adversely affect. So they have that process, they talk to the Fish and Wildlife Service. The agency says, we believe our agency action may affect, but is not likely to adversely affect. We would like your concurrence. They send whatever documentation to the Fish and Wildlife Service. If the service concurs, again, action agency is done. It doesn't have to move forward with any further Section 7 consultation. If the service does not concur, which happens, then they have to move to formal consultation, or at the minimum, another round of informal consultation. And so in my practice, for example, I have a case involving the EPA's approval of water quality standards in Kentucky for selenium and nutrients. And EPA approves the state's water quality standards on a triennial review basis. And EPA sent a biological evaluation saying, here's the species, here's how these particular standards are not going to adversely affect the species. Could you give us your sign off? The Fish and Wildlife Service wrote back and said, no, we don't have enough information. You don't have the right list of species. So, here's the list of species. Like, you got to go back to square one. So even though most NLAAs do get concurrences, it can certainly happen that an action agency gets a little bit ahead of itself and doesn't have the full amount of information that the service wants to see in order to be comfortable concurring with that NLAA. So, much like sort of the EA, EIS, an agency can decide on its own. Okay, we already know there's going to be adverse effects. We might as well move to formal consultation. So whether it's the service telling them they need to do more work or whether they figure that out on their own, if there are going to be adverse effects, they have to move to formal consultation. In the formal consultation process, usually there is a written document by the action agency evaluating all the impacts. And then they send that document to the wildlife agency. The wildlife agency prepares its biological opinion. So much as in NEPA, they have to consider the baseline. What is the status quo? Where is the species? What are all the effects on the species of human activities or other factors, pushing them towards extinction? What's the snapshot of the species' current state in time? What are the effects of the action? Again, just like with NEPA, you have to consider direct, indirect effects. And you have to consider cumulative effects, which by regulation are defined to be everything that's not a federal action, essentially, because the theory being that we're going to capture future federal actions through the Section 7 consultation process. But if there's reasonably foreseeable state actions, private actions that are going to affect the species, we got to put all this into the hopper and consider what are cumulative effects on the species going to be. Both agencies have an obligation, again, to use the best available scientific and commercial data. The fact that there may be a paucity of data is no excuse. They have to make the best decision they can based on the information they have, and they have to look for that information. So once the Section 7 process is done and a biological opinion issues, if the service determines that there is no jeopardy or no destruction of adverse modification, it issues a no jeopardy opinion with an incidental take statement saying, you're out from under the prohibitions of Section 9. Here's the level, the quantity of incidental take that you're permitted to have. So essentially, this is a permit. And here's what you have to do with respect to what is called reasonable and prudent measures to minimize the impacts of your incidental take. Here's your terms and conditions that you have to comply with. And here's essentially, the ITS is meant to provide a trigger. Here's when you have to come back to us if you've gone over what we originally thought would be, permissible incidental take at the no jeopardy level. So the federal agency does have an obligation to reinitiate consultation if it retains discretionary involvement or control, if the incidental statement is exceeded. Again, it's like the SCIS in the NEPA context. If you have new information, a newly listed species, and you have an ongoing action, then you may have to go back to the service to reinitiate consultation based on that new information. This is really, sort of the nuclear scenario. The jeopardy opinion is certainly the ultimate hammer that the service has. If it does find jeopardy, it has to try to find reasonable and prudent alternatives to jeopardy that the agency can implement to still get whatever it was that it wanted to get done, but that will avoid jeopardy to the species. So one of the things that's important to realize, a biological opinion is it certainly has legal effects, real world effects. Most agencies will comply with whatever the biological opinion says, but it is actually within their discretion to disagree. It is an opinion. It's essentially an advisory opinion. It's the wildlife agency saying, this is our best judgment about whether you meet the jeopardy standard, what you can and should do. But the agency has a substantive obligation at the end of the day to say, okay, thumbs up, biological opinion, we've got your ITS, your RPMs, we're totally going to live with them. Or, oh my God, it's jeopardy, but hey, we're going to implement the alternative that you've told us will avoid jeopardy. So it's important to understand that, at the beginning of the day and the end of the day, the action agency is the one that bears the ultimate responsibility for complying with the biological opinion and choosing or not choosing to implement what the Fish and Wildlife Service or NIMS recommended. I'm going to very quickly through. This has happened so rarely in the history of the world. It's only happened several times. But what happened after TVA v. Hill is Congress said, wow, we didn't really realize that what we said was projects are going to have to stop if it would jeopardize the species. So let's set up this exemption process called the God Squad. If TVA v. Hill, the Tellico Dam is going to close, the snail darter is going to die, maybe we're going to decide the snail darter should die. The benefits of the Tellico Dam are more important than the snail darter's survival. So it set up this process essentially to go to this group of cabinet level members who have the ultimate ability to say species lives or species dies. So, this was certainly big news, but it's only ever happened 3 times in the history of the ESA since 1978. What really happens under the statute, much like in the EIS-EA process, there are way more informal consultations than there are formal consultations. So this is a graph that people at my office have put together analyzing essentially every Fish and Wildlife Service consultation that has happened since fiscal year 2008. The blue lines are, the total number is all consultations. The yellow on the bottom is how many actually went to formal. The vast majority of those biological opinions are no jeopardy opinions. Less than 1% of all biological opinions end up in a jeopardy opinion. I mean, it's almost so small a number as to become noise and not data. So most of the time, as in the EIS process, it doesn't go to the full-blown formal consultation with a biological opinion, and then the vast majority of the time, the agencies are not going to find jeopardy. And it is an iterative process. I mean, certainly during the consultation process, a project applicant can come in and say, what about if we shift our pipeline here? What about if we don't drill over there? Certainly there's every opportunity in the consultation process for the action agency, the permittee, whoever, to try to figure out how to mitigate impacts on endangered species such that the ultimate outcome is going to be a no jeopardy opinion. Very quickly, because I know we're really out of time, I mentioned at the beginning, Section 9 is really where the rubber hits the road. And so one of the very interesting things about Section 9 is it applies to any person. So this is not just an obligation on federal agencies to avoid take. It's an obligation on all individuals and an obligation on all state agencies. So, for example, state agencies have been held liable for issuing permits that result in the unpermitted take of endangered species. And as a matter of fact, in Massachusetts, a pro se plaintiff brought a case successfully against the Massachusetts Fisheries Department for not, ensuring in its permitting process of lobster fishermen that those the lobster gear was not unlawfully and unpermittedly taking right whales. So
maybe you want to explain just what pro se is.
I'm sorry.
Pro se is representative.
Yes, he, not an attorney, not just as a private citizen, brought this case and won. setting, an important precedent that state agencies can be held liable through their permitting programs if they have not fully examined and gotten permission for incidental take of their actions. So this is something that can be enforced by the Department of Justice. So there can be civil and criminal penalties that can attach to violations of the ESA. And also importantly, it's enforceable through the citizen suit provision of the Endangered Species Act. So in a citizen suit context, you cannot go after violators of the act for past violations, but to the extent that past violations show or there's a likelihood of future unpermitted incidental take, you can seek as a private citizen or organization injunctive relief, and courts have jurisdiction to grant injunctive relief against activities that are likely to result in take of species. One thing that's really important to understand is, take is so broadly defined. It's not just like I go out and I trap this animal. It can be I go out and I, build a strip mall on this animal's habitat in a way that is likely to actually kill or injure. Or, for example, in the context of national forests, my timbering activities are going to go out and, cut the trees that are the habitat for the marbled murrelet or the spotted owl. And this case citation is Babbitt versus Sweet Home chapters for a greater Oregon. And essentially what the Supreme Court said in this case, another high watermark of ESA jurisprudence, was that the agency's regulations defining take so broadly as to include habitat modification that actually kills or injures wildlife is an acceptable regulatory interpretation of the statute. So again, very quickly, Section 10. If you have no section, a Section 7 incidental take permit will flow through to cover incidental take, by a private party. So if I'm a pipeline company and I'm building a pipeline and FERC has to go do a consultation with Fish and Wildlife Service, the incidental take statement that FERC will get in its biological opinion on certificating the pipeline will flow through to me, the pipeline company. But if you're an entirely private person on entirely private land and there's no federal nexus, you don't need a federal permit of any kind, you're not going to get your Section 9 coverage through the Section 7 process. So therefore, there is a process under Section 10 for getting incidental take permits. And so what private parties will do is come to the Fish and Wildlife Service and say, here's what's going to happen, here's what we're going to do, here's how we're going to mitigate this. We're going to have a habitat conservation plan, here's how we're going to fund it, here's how we're going to carry it out. And the wildlife agency will become the action agency. So they will issue this permit, they will approve this permit, they will do their own Section 7 consultation on this permit. And this is a way that private parties can get certainty and avoid the specter of a Section 9 suit hanging over their head. There's also provisions under Section 10 for scientific researchers to go out and get incidental take authorization. So for example, if I'm a dolphin researcher or a right whale researcher and I'm going out and I want to tag whales, that is a take. It is an actual injury to put a tag on a right whale, but it's for a greater scientific purpose. So therefore, I can get my Section 10 research permit through the wildlife agency. Section 11 is all about judicial review. So as I mentioned before, private citizens can actually enforce the ESA, much as there are citizen suit provisions under our other environmental statutes, such as the Clean Water Act. The one part of the ESA citizen suit provision allows private parties to enforce the ESA against agencies for violating their obligations under the ESA, such as Section 7 obligations. So if an action agency has completely missed the boat and not consulted, or it has conducted a consultation that in the private party's view, it's not scientifically based, it's arbitrary, it was a done backroom deal, that can be challenged in court, and that is something that's reviewed on the record usually. Any private person can also sue the secretary for violation of mandatory non-discretionary duties under Section 4. So essentially, those are your missed deadline suits. In either of those cases where you're bringing an ESA citizen suit, you have to give the alleged violator 60 days written notice copied to the secretary before you can initiate suit. So essentially, there needs to be a 60-day cooling off period in which the alleged violator can see the error of his ways and cure them or not. So the interesting thing, though, is that the Supreme Court found in Bennett v. Speer that the Wildlife Agency cannot be sued under the citizen suit provision for administering or maladministering the Endangered Species Act. So what Bennett v. Speer found is that if you want to challenge a biological opinion, that's not an ESA citizen suit. That is the secretary exercising his or her scientific judgment and administering the statute. It's not like a mandatory non-discretionary duty, so it's not an ESA citizen suit, but it is challengeable because it does have legal effects, and therefore the APA, which is your default cause of action when there's no other cause of action, that's your way to get into court. Although in either case, again, going back to the importance of administrative law, the Administrative Procedure Act will always supply the scope and standard of review, essentially either failure to act under a 706(1) theory or arbitrary and capricious action under a 706(2) theory. So really the difference it comes down to is whether or not you have to file an NOI. Although I will also mention that there is a growing body of case law saying essentially that the ESA suit is the general way to get into court unless there's a more specific statutory remedy prescribed by Congress. So for example, a court here in DC, the DC District Court recently found that in challenging EPA's compliance with FIFRA, which is the pesticide registration statute under the ESA, that was something that has to be brought in the Circuit Court of Appeals, which is what FIFRA prescribes for challenges to pesticide registrations rather than in the district court under the ESA citizen suit. So, if you're ever going to be an ESA litigator, you need to know how you're going to get into court and which court. Again, trying to wrap it up. I know we're going really long. Has the ESA worked? As I said, the point of the ESA is not just to maintain a list in perpetuity. It's actually to survive and recover species. And there are more than 1,400 species listed under the ESA that are in the United States. Since their listing and the statutory enactment, only 10 have been declared extinct, 8 of which were likely extinct before they were even listed. And the Center for Biological Diversity did a very interesting study looking at the recovery rate and found that that species that are listed, are, generally they might not be recovering quickly, but many of them are on the path to recovery, including a number that have been successfully recovered to the point of delisting. And they also found that, there are a number of species that you can say without the ESA, they would have gone extinct. And critical habitat does have an impact because species with designated critical habitat are twice as likely to be recovering as those without. So it's certainly beyond the scope of this very basic introduction to talk about what's going on the Hill. It's a full-time job to keep up with what's going on the Hill with respect to various amendments, trying to amend generally or specifically the ESA. There's also a lot that's been happening at the regulatory level with Fish and Wildlife Service and National Marine Fisheries Service coming out with proposed regulations to, in their view, reform and better implement the Endangered Species Act. But I think that many times there is a narrative of failure around the ESA. The ESA is a failure because we haven't recovered all of these species. But what I believe is a narrative of success, and that it is certainly the most potent and powerful biodiversity protection law of any country. And that to the extent that there are instances where it can be said it's not a success, it's often not a question of the statute being broken. It's a question of political will. It's a question of dollars, and it's a question of the value that we put on biodiversity and our country's biodiversity resources. I did have a couple of other slides in here about other related wildlife species protection statutes, but we're just going to skip right all over those since we are more than over time at this point, and I thank you for your attention.
All right, so let's give a round of applause. I know that some folks online have questions. What I would like to do for those people, because I don't want to push the time too much longer, is if you wanted to send me an email with your questions, I can pass them along to our panelists. My my last name is Sarnowski, SARNOWSKI at ELI.org. You can find me on the website. For those in the room, if you wanted to maybe take a few minutes, I don't know if
I'm completely
some time
whatever questions.
to ask
Yeah, and I'm
questions.
I don't know
happy
how
to.
many you got.
If you wanted to stick around and we can ask some questions.
Yeah, I'm happy, and I'm also happy to answer online ones too.
That sounds good. I mean, there's a lot of information to absorb that was just thrown your way. So let's start with the people in the room. And for those folks online, I haven't forgotten about you, but we might have to defer your questions for email purposes.
You talked about available science. Have there been any discussions on how far somebody needs to look? And have there been any Information Quality Act litigation on that?
Well, with respect to information quality, the services send out their status reviews to peer review. So that is basically standard operating procedure at this point. With respect to the quality of information that is coming in, like at the petition stage, for example, they're essentially supposed to look at that and say, does the information presented support the requested action? But they don't start doing like the peer review until they've completed the status review. And there has been some case law on essentially, like the agency does not necessarily have an obligation to click on your links. So when you send data to an agency, it's best practice to actually make a copy of it and send it to them, because if something is like in a scientific journal behind a paywall, they don't have to go pay to go get it. So there definitely has been some fleshing out of what available means. And, certainly a bright line rule is they don't have to go out and create data. They don't have to go out and do the research. And so from the practitioner's point of view, best practice is to make it available by putting it in front of them. But they do also have a duty to search through their files to see like generally available information. And the real quality control comes in at the status review stage when they exercise their best judgment, and at the peer review stage when they send it out to scientific experts and certainly there have been any number of cases where the peer reviewers have come back and said, yay, great job, and there are also some cases where they have come back and said, we're really not sure what you're thinking, your conclusion is not does not flow from the information you've looked at.
The only thing I'll add to that is there's a proposed rule out there now about the petition process where they would propose to have petitioners go to their states first and let the states have first crack and be able to comment before that initial petition is submitted, and then the petitioner would have to certify that they did certain pre-application activities to include in their petition. The perception is that not all petitions are created alike, and you have multi-species petitions, and so they're trying to simplify or standardize the petition process a little bit and get at some of where they're getting a lot of political pressure from individual states. They're trying to appease that a little bit by giving them some more role on the front end. So that's only proposed. It's out for comment right now, but that would affect the content of petitions and information.
Thank you. But first, I just want to thank you both for coming here and speaking on your issues. I don't want to ask you a specific question, James. You mentioned one of the benefits of NEPA is greater coordination between states. But I wanted you to comment on, I guess, the current political climate, because especially with a lot of the states that have now representatives from, maybe the Tea Party, they're very much, kind of railing against the federal government and more into, we should do things we do in the states. Do you think that that push towards states' rights is going to hinder the NEPA in terms of its implementation? What do you think?
Again, just answering off the top of my head, I don't think it'll manifest itself too much in NEPA. I mean, the first, we didn't talk very much about it, but a lot of states have their own mini NEPA, and a lot of them are worse news. if you're a developer than they are the federal NEPA. California, New York, they have substantive provisions where you must select the environmentally preferable alternative, and you must adopt mitigation for identified adverse impacts. So at the state level, you have similar processes. One of the issues is how do you merge? Is the state little NEPA review sufficient for federal purposes or not? Those are issues. So getting, I think those get done anyway, and your substantive permitting requirements are what they are for Clean Water Act, Endangered Species Act. But the NEPA is often a vehicle to do all of those analyses in the same document. So coordinate different agencies' environmental reviews, so they're all done together. So I don't think it's in the NEPA standpoint you're seeing that tension. It's should we be requiring Clean Water Act permits for this kind of water, period. And if so, NEPA is a good vehicle to get everyone on the same page.
Although I'll elaborate on that and say that where we see it as a DC-based organization is efforts in Congress to attach riders or put provisions in bills saying essentially no NEPA shall be required on a highway project, or if there is going to be NEPA, you can't challenge it in court. Like there's lots of congressional attempts, political attempts to limit NEPA, limit public participation and or limit judicial review opportunities. So, one thing that's important to my organization as a nonprofit is that, the comment process under NEPA, the public participation process, is supposed to be a two-way street. It's not only supposed to inform the public of what the federal agency proposes to do, but it is also a process by which the public can raise issues to the agency that the agency may not have considered. So, a NEPA process is often the only opportunity for the public to be informed, especially on some of these larger projects, as to what the impacts might be. And so, from our point of view, attempts to limit NEPA, to limit that sort of full and free airing that's, again, not supposed to lead to a particular outcome, but is supposed to be a process that ensures that decision makers have the best available information, on which to make their cost-benefit analysis. That's something that is of huge concern.
Yeah. On the flip end, though, some of the change. I mean, I think they're not changes to NEPA so much, but you see them again in authorization bills for different sectors, and I think everybody can agree that if we can get the input at a time early when it's most reasonable, get the biggest net at the table early, and sort of, because the countervailing consideration is if you hate a project, you're probably looking for any way to kill it, and you can save your comments to the last minute, and then it's like a sandbagging kind of effect. So I think there's interest in good decisions, but there's a tension of how can you get this done in a reasonable amount of time. I mean, for the most recent transportation legislation, set an outer limit of 4 years on an EIS or for certain kinds of projects. Again, that's not a lot of proposals like that. I think I'm of a mind that an arbitrary time is kind of arbitrary. I mean, who knows? It's 2 years, 3 years, 4 years, but any kind of thing that forces everybody to show their cards at the front end, I think is useful. Is useful to everybody. Unfortunately, there is some gamesmanship on both ends in that regard.
So there's a House appropriation bill right now that has 20-some riders, including barring the listing of the greater sage grouse and legislative delisting of the gray wolf. If that were to go through, what does that mean for the conservation of those species and also for the way these acts function and, for instance, for the Fish and Wildlife Service in achieving its primary mission?
Certainly our view at Defenders of Wildlife is that, Congress, when it originally enacted the ESA, entrusted the expert wildlife agencies, Fish and Wildlife Service and National Marine Fisheries Service, with, the ability not only to list species, but also to ensure through the Section 7 process or the Section 10 process that incidental take can occur as long as it doesn't meet that jeopardy standard. So, I'm certainly not a sage grouse expert or a wolf expert. There are people in my organization that's all they do all day, every day. But, with respect to those writers, I think oftentimes there's a public perception or congressional perception that, an ESA listing means it's going to be like, oh my God, we can never do anything in sage grouse habitat or wolf habitat again. And I think that those reactions are driven by, let's say, not facts. They're driven by ideology. They're driven by misconceptions. They're driven by just outright myths. And so, especially, for example, with like the lesser prairie chicken, for example, another one that, Congress is meddling in, they're like, oh my God, if you, go forward with this lesser prairie chicken, you're going to interfere with national security. The Department of Defense is not going to be able to do its training. And the Department of Defense has said, it's not a problem. Certainly the Department of Defense agencies are extremely used to working with the Fish and Wildlife Service. And in fact, they do, in many cases, a really great job of balancing and implementing species protections on federal lands where, bases can be some of the last habitat for some of these listed species. So I think that, I think that a lot of those writers and, attempts to amend the ESA piecemeal or to, make special exceptions or cases for certain listed species, I think they're highly problematic because they're certainly not science driven. They're not something that necessarily the federal agencies are asking for. And, in many cases where, for example, the Fish and Wildlife Service, I think in the sage grouse context, has been working very hard with states and affected sectors of industry and landowners to come up with, conservation agreements that allow development and yet will still result in conservation. I think, it's really taking a very blunt instrument to smash up a lot of work that, the federal agencies and, private parties and states have put a lot of hard work into, trying to have a balance between conservation and development. So, certainly my organization will say, and I agree, I think it's really not appropriate, especially, on this sort of piecemeal writer approach, to come in and try to fix something that's really not broken.
Yeah, I have nothing to add to that. I think riders they tend to have unintended consequences. They're of like an earmark, kind of variety. They are very one-off. I think the intent, and I don't think it'll be accomplished legislatively, is, I mean, while things can be delisted, it doesn't happen very often. I mean, I think that, it's just a reality that the services are so strapped for everything that they're charged. I mean, everything that James talked about, so many different responsibilities, recovery plans and critical habitat and listing and doing 5-year reviews, and before you're done, you're ready to do another review, and there's just not a lot of manpower or money, out there to do it right now. So I think focus on one of the things that gets kicked down the line is delisting petition. I mean, once a species gets on the list, it's very hard to get it off, and that, I think, is a lot of the fear listing things in the first place, the fear of what's going to happen, once it's listed, and is it ever going to come off, and conspiracy theories about, was listing it really a swipe at mining or oil and gas industry, or we don't really care about the grouse, we care about setting aside 200 million acres for as off limits to a certain kind of activity. It should be part of I'm not barring. I think the ESA is good. I think it's been beneficial. I think it can be improved, but doing it piecemeal through a rider is probably not the best way to do it, I guess.
All right, so I think we're going to end on that because we're almost half an hour late, but I do want to thank everybody for participating. Thank you for staying a little bit longer. Thank you to the folks online. You can see that these two statutes really are intertwined, and practitioners in the field do deal with both of these statutes, I mean, all the time, and it's important to understand. This was an overview, but when you're really practicing in this area, you're in the weeds, you're looking at each provision and seeing how it plays out. So thank you very much.
Thank you.